And welcome to this scenario, a breakdown of Arizona's fake electors case, what we've learned after 2 court hearings and what we still have yet to learn. Joining me are Mark Kokanovich. He is a former federal prosecutor in Arizona who now represents white-collar clients in civil and criminal cases at Ballard Spa in Phoenix, and Michelle Hogan, a former state prosecutor at the Arizona Attorney General's office who now handles civil and criminal cases at Jayberg-Wilk in Phoenix. Thanks so much to you both. A lot of questions tonight. Cases still relatively new, but a lot of questions. All defendants are presumed innocent until found proven guilty in a court of law. We all accept that. Mark, 18 defendants, 9 felony charges apiece. What is this case really all about?
Well, like you said, it's a fake elector case. It's an election interference case here in Arizona. Several cases around the country have been charged similar to this one. These people claimed to be electors that were duly appointed and certified when they weren't. And electors are the people who vote for the president. We all vote for electors, and then the electors vote for the president. These people claimed to be the electors that were selected, and they claimed to do that in contravention to the actual votes that were counted and the certification of then Governor Ducey.
So, Michelle, how do you spin that out into fraud, forgery, conspiracy charges?
So those are the bread and butter of the Attorney General's office, because typically you have a false writing, something that someone signed and used to defraud another individual. And here we're submitting these fake electors both to state agencies and to Congress in an attempt to influence this election and present another winner for the election, Donald Trump.
Now, we've talked about that there has to be a benefit involved to make this case.
That's right. One of the charges is fraudulent schemes and artifices, which requires the state to prove that the individual charged committed this offense, and part of this was to receive a benefit. And here we've talked about the benefit to these fake electors could have been to help support the candidate that they wanted to win, which is Trump.
So it doesn't have to be a financial benefit or really tangible benefit.
Right, intangible benefits count as well as anticipated intangible benefits.
Okay, good definitions help to set the bar here. News of the day, if you were the crime-busting prosecutor Rudy Giuliani back in the day, would you, Michelle Hogan, have accepted what Rudy Giuliani, former Trump lawyer, did today and over the last 3 weeks in not accepting the summons to show up in Phoenix?
No, I agree with how the state argued for him to have to come and present for booking and put up a bond, because he has evaded service of the summons intentionally and has stated so on the record that he was evading service. He didn't provide any location that he was going to be at, contrary to what he said at the hearing.
He said, I said it on the radio, I said it everywhere. Everybody knew where I was going to be, no?
No, he was not providing a location for the AG's office and their agents to find him to serve him.
How serious is what the court did? A $10,000 bond basically to show up, and he's got to be in Phoenix in 30 days, I think, to be fingerprinted and mugshotted and do the other basics.
These things are relatively common, but as we've said, he's the only one who had those additional conditions placed on him because of the actions that he took. And as Michelle said, he wasn't making himself available to the AG's office. He knew that this was out there. He hasn't even bothered to read the indictment yet. And he was bragging on Twitter about how they hadn't captured him yet and hadn't found him yet, and that he said on Twitter that they would need to dismiss the indictment if they didn't serve him by the next day. That's all a lie too. There's no rule about dismissing an indictment if you're not served with a summons.
But could the court have issued an arrest warrant, say this week even, if they hadn't served him last week?
Yes.
Rudy Giuliani could have been arrested.
Could have been, but fortunately they were able to locate him because, as you said, he was bragging about evading service, which isn't a very good idea to do. And then he went and deleted that tweet. And of course, the internet never forgets. The tweet's been saved.
It certainly doesn't. Let's go back to the grand jury process. There was a really interesting story a few weeks ago in Politico talking about the grand jury process, how the grand jurors seemed to hijack the case. They indicted people that the AG's office didn't necessarily want to indict, and there was a suggestion it was the MSNBC grand jury. You've been in that room with grand juries. What did you make of that report?
Well, keeping in mind it's always the grand jury's investigation, and it is their indictment that they're signing off of. So when a prosecutor is presenting to a grand jury, the prosecutor is presenting their draft indictment, and they instruct the grand jury that that's not the final indictment. They don't have to sign off on that as exactly as written, and they're free to make amendments. So it's always possible when you have a grand jury that's interested in a case, listening to the evidence, may see issues or extra defendants that the prosecutor didn't initially charge and can write on defendants. But we don't know that for certain. It could be that the prosecutor simply reviewed the evidence and found that there were defendants that maybe weren't initially going to be charged, but ultimately were charged.
And to be clear, I mean, help us understand how a grand jury works. It's not like these folks just showed up one day and were asked to listen to testimony and make some decisions. They sit for a while.
Right. The grand jury for the state is impaneled every 6 months. So they're sitting and hearing cases several days a week on occasion. And so they get to know these charges, particularly fraud schemes and forgery, and they know the elements and they're familiar with these types of investigations and can think of sometimes pointed questions to ask.
So is the dynamics such that they just kind of, after a time, they know their own minds? And they know what they think about this case maybe better than the prosecutor does?
I think that can be true. I think they take their job seriously and want to be serving the public. And if they see an opportunity to ask a question that maybe the prosecutor isn't asking, they're going to do so.
I'll go to you with this one, Mark. Also a grand jury question, but this might be the largest single political case or single prosecution, 18 defendants since ASCAM. If anybody remembers that, back in 1991, a major political corruption case. How does a federal prosecutor, state prosecutor, get its arms around such a huge case?
Well, it is a huge case, lots of defendants. One of the things that we can expect is that some of them will plead guilty. That's
plea deals?
Plea deals. Plea deals have happened in other cases around the country, and we can expect them here too, where people will accept responsibility for what they've done in exchange for a more lenient sentence, possibly cooperation. And another thing that's important to recognize in this grand jury proceeding is that it's been framed as kind of a Democrat Chris Mays against Republicans who were these fake electors. And I think that that's a really false framing. You have two career prosecutors who've worked for Republicans and Democrats. I've worked with one of them.
You mean the line prosecutors?
The line prosecutors, Nick Klingerman and Krista Wood, both of whom are career prosecutors. They're not political animals. They're not running for something next week. They didn't get elected to this job. They've been prosecutors their whole career. They charge white-collar crimes, and that's what they did in this case. And it's the grand jury, as Michelle has said, rightly, that ultimately is the body that charged these individuals.
We heard from the lawyer for former Arizona Republican Party Chair Kelly Ward today. She and her husband, Michael Ward, have been indicted on 9 felony charges. Kelly Ward sort of led the signing. People may have seen that on social media in December of 2020. This case is 3.5 years old, almost 4 years old. You have to keep reminding people what it's all about. At least I find. And the Ward's attorney said, you know what? The charges aren't defined. We don't know what they're all about. Is that a legitimate criticism?
I don't think so. Well, first, we have just notice pleading in Arizona, so where you have to give the defendants notice of the charges against them, and that's pretty minimal standard. for
And that's what's happened
prosecutors.
over the last week or so.
Right, and through this indictment. And I think the prosecutors did more than that here because they wrote out a narrative after the charges describing what constitutes these individual charges.
Now, I imagine there were 11 electors, 11 Trump electors initially. I imagine each were told different stories about what they were doing. Is it a legitimate defense for one of them to say, you know what, I was told this was legal. I signed it. Am I guilty of something? Is that a legitimate defense?
No, usually not, and it doesn't usually work that way to say that you made a legal mistake because we're held accountable for those actions. And here, I think there was more than that, and I think the evidence will hopefully show more than just an innocent mistake, and I would assume the prosecutors would have that before charging and taking it to the grand jury.
Yeah, and as I've discovered just in reporting and going back over the court files, and the emails, the text messages, the voicemails, Rudy Giuliani, for one, it is a fact that he was involved in trying to overturn the Arizona election from November of 2020 all the way through the few days before January 6th when it was certified. So there is a voluminous file of evidence out there. Is that enough to convict? Are those emails, text messages enough?
Well, the evidence, a lot of it is, well, the allegations are in the indictment, using the defendant's own words in many cases, and Rudy Giuliani's own words to Rusty Bowers. Those are powerful
It's a
pieces,
voicemail, yeah.
Right, powerful pieces of evidence that may be presented in court. These are serious charges that have serious consequences, and the fallout is really critical for everyone in Arizona. The mistrust that was sown in our elections is still with us today, and Rudy Giuliani is still maintaining that people in Arizona can't count votes when Doug Ducey disagrees and the Republican Board of Supervisors disagrees. So,
Still early, but let's look ahead. Trial dates are being set in court. How real are they? They're as early as October 10th, I think.
I've never had a case in my career that wasn't delayed or a motion to continue wasn't filed, particularly by the defense. The prosecutor is usually prepared to go to trial at the earliest date, but it's in the defense's best interest to keep pushing dates off because, you know, memories fade and it always benefits the defendant to have more delay.
And do they have to do discovery, get the opportunity to do discovery, see what others have said? How would that work?
So in the state's process, here in Arizona, the prosecutor just turns over everything they have in the initial disclosure. So there isn't a back and forth with the state. I'm sure these defendants will come up with witnesses that need to be interviewed or deposed depending on their willingness and expand discovery maybe beyond what the prosecutor has.
So what's a more reasonable calendar for these cases? Going well into next year, going well into even into 2026?
a reasonable calendar is not something that the defense is going to be worried about, I don't think. I agree with Michelle that I think the defense is going to want to push this off as long and as far into the future as possible.
But that gets expensive.
It gets expensive, not if you have a public defender. It's expensive for the taxpayers, but that's part of what we have this process for. And the judge is there for a reason. The judge gets to decide whether or not to grant extensions. There is voluminous material in this case. I imagine discovery is going to be very, very large. Like you said, this has been going on since 2020. So there are a lot of text messages, a lot of electronic information that I'm sure will need to be gone through.
All right. Michelle Hogan, Mark Kokanovich, thanks so much for joining us. And thank you so much for joining us.